on live on YouTube. We are now live, and we are here with Legislative Council meeting with the Senate on the sexual harassment prevention policy. Thank you, Luke. Appreciate your time very much.
Well, thank you very, very much, Senator. And good morning, everyone. My name is Luke Marland. I am the Director of the Office of Legislative Counsel and Chief Counsel to the General Assembly. And it's very nice to see all of you. For those of you who are returning, it's great to see you again and welcome back. I think we're excited about the upcoming session. And for those of you who are new, it's very nice to meet you, even though it's only remotely. And I think all of us look forward to getting to know you a little better over the next few weeks and months as we appear before your committees. I'm joined today by three of my colleagues, Katie McClinn, Damian Leonard, and Jennifer Carby. And the four of us are going to conduct a training on the prevention of sexual harassment policy. Now, to do that training, I'm going to put up a PowerPoint in a few moments that should appear on all of your screens, or you should be able to see. And Vanessa, please don't forget to make me a co-host. And when I put up that PowerPoint, it's sometimes, as you know, in Zoom, a little difficult to see everyone's tile, everyone's picture. And so I would ask you to save questions till the end. We think they'll be more efficient. We definitely want to try to answer your questions. We want to hear them. But I think it's best if you let us get through our presentation, and then at the end, we'll leave time for questions. So without further ado, I will put up the PowerPoint, and then Katie, once it's up, I think you could begin.
Great. So we're going to start off this morning by covering the goals of this training, what we'd like everybody to leave here understanding today. So in terms of our goals, first, we'd like everybody to understand what sexually harassing conduct is. Second, we'd like to make sure attendees know their options if they feel that they've been sexually harassed. Third, we want to empower attendees to make informed choices regarding whether and how to seek a resolution. And lastly, fostering a positive and sexual harassment-free culture in the State House. The General Assembly has adopted a sexual harassment policy. The policy covers all legislators and all staff of the General Assembly. It also protects us. It protects legislators, it protects staff, legislative pages and interns, and also members of the public, including lobbyists, advocates, and members of the press who interact with legislators and staff.
I apologize, I was muted for a moment there. The policy specifically prohibits two things. The first is sexual harassment, and the second is retaliation for either reporting sexual harassment or for cooperating with an investigation of sexual harassment. And this is really important to remember. It prohibits both the behavior itself and also retaliating against someone for utilizing the policy to protect themselves from the behavior or from cooperating with an investigation of whether behavior occurred. So the next question is, what is sexual harassment? So sexual harassment is a form of sex discrimination, and it means unwelcome sexual advances, requests for sexual favors, and other verbal or physical conduct of a sexual nature when submission to the conduct is made either explicitly or implicitly a term or condition of employment, or when submission to or rejection of the conduct by an individual is used as a component or as the basis of an employment decision that affects that individual, or finally, when the conduct has the purpose or effect of unreasonably interfering with an individual's work performance or of creating an intimidating, hostile, or offensive working environment. And that last piece is very important there. It's the purpose or effect. So if a behavior has the effect of creating an intimidating, hostile, or offensive working environment, it is prohibited by the policy, regardless of what the purpose or intent of that behavior was. So We're going to move into examples of sexual harassment from the policy, with some examples from real life that we've taken from cases around the country. Here, these are cases that we thought reflected the specific terms in the policy, just to give a better understanding of what might be prohibited. So the first thing that's prohibited, as I mentioned before, is explicitly or implicitly conditioning a term of employment, which could be continued employment, wages, good evaluation, promotion, or assigned duties or shifts on the provision of sexual favors. An example of this is where an employee was told that her job was to keep the boss happy. And she ended up not feeling like she could ask him to stop touching her, including groping her in elevators.
Thank you.
Or touching sexual parts of her body without her consent. And
Fine, thank you.
Senator, I believe you're unmuted.
Oh,
And she ended up sending him a nude photo at his request because she feared that she would lose her job if she objected or did not comply to that request. Related instances for our workplace are that legislative staff or lobbyists may feel pressured to comply with or not object to things like hugs, social media friend requests, requests to share a personal cell phone number, or other behavior of a personal nature from legislators because of the actual or perceived power differential that exists, and concern that their job security might be affected if they don't agree.
Another example of potential sexual harassment is touching or grabbing a sexual part of a person's body. And the sexual parts of a person's body could include the buttocks, the groin area, or the breast. You should never be touching or grabbing those parts of a person's body. Sexual harassment could also be based upon touching or grabbing any other part of a person's body after that person has indicated that the physical contact is unwelcome. For example, it could be grabbing someone's arm or someone's shoulder. If the person has indicated that that contact is unwelcome, they can indicate it verbally. They could tell you to stop. They could indicate it by sending you an email, but they could also indicate it in a nonverbal fashion, for example, by pulling away or flinching. In other words, if the person says or does anything that indicates that they don't want to be touched, don't want to be hugged, you should immediately stop that behavior and not do it in the future. Another example of sexual harassment involves continuing to ask a person to socialize either on or off duty when the person has indicated a lack of interest. To take an application, it could involve repeatedly inviting someone to accompany you on a weekend ski trip or something similar. It could involve repeatedly asking someone to join you for just one drink. As with the physical contact example that we just talked about, if the person indicates in any manner, telling you to stop, telling you they're not interested, or perhaps avoiding you, or in any other way indicating that they don't want to socialize with you, you should stop that behavior and not invite them again in the future. Another example of potential sexual harassment is displaying or transmitting sexually suggestive pictures, objects, cartoons, posters, or other visual matter if it is known or should be known that the behavior is unwelcome. Now, some examples from other situations have included sending unsolicited explicit photos via Snapchat or some other platform. Screen sharing when you're on a Zoom or other meeting and tabs are open that could display or suggest explicit content. Having any kind of suggestive picture or image in the background as you conduct a Zoom meeting. All of these could potentially be the basis for sexual harassment, and even if they're not, they could be unprofessional. So in this context in which you are doing your business remotely, we want to stress to you to please think about what people see when they're watching you on Zoom. The books in your bookcase, the pictures behind you on a wall or on a table, even if it might not be sexual, it still might be something that makes someone uncomfortable. It still might be something that's unprofessional. So please be aware of that. Another example of sexual harassment involves continuing to write sexually suggestive notes, letters, emails, text messages, if it is known or should be known that the person does not welcome those messages. To take an application, it could involve sending explicit emails or jokes to either your colleagues or staff or someone else who works in or for the General Assembly. Now, on a related note, there is a chat function in Zoom, as most of you know, and that can be used for comments during a committee meeting, for example. But please be aware that it would be inappropriate to make jokes or comments about how someone appears or how they're dressed. That may not necessarily be sexual harassment, but it still may make someone uncomfortable and still might be unprofessional. So please be aware of that.
Some other examples of sexual harassment include referring to or calling someone a sexualized name if it is known or should be known that the person does not welcome that behavior. And some applications of that might be calling someone like an intern something like little girl or little boy or sexy. It could also be calling subordinates or colleagues names like honey or darling. You might think that that's just being friendly, but being on the receiving end of that, it can feel creepy or unprofessional. And another application, it would be using sexual or explicit language to refer to subordinates or colleagues. So vulgar terms or explicit language should not be the way that we are referring to colleagues or subordinates or other people around in the State House. Another example from the policy is regularly telling sexual jokes or using sexually vulgar or explicit language in the presence of a person if it is known or should be known that the person does not welcome that behavior. So Luke spoke about telling sexual jokes. This again is a reminder that telling sexual jokes in the workplace can be considered sexual harassment. Some other applications could be talking about your own sex life or other people's sex life, or talking about celebrities with whom you'd like to have sex. None of that kind of language or conversation belongs in a work environment. And on a related note, we just wanted to remind you that even when you're not streaming live on YouTube, when the committee is gathering in the Zoom room before going live, the Zoom room is still a workplace. This is the platform that we're meeting on right now because we can't be in the State House. And so once you're in that room, once you're in the presence of your colleagues or staff members or witnesses for your committee, it's still a workplace. It's still a professional environment where sexual harassment is not tolerated. And another example is retaliation of any kind for having filed or supported a complaint of sexual harassment. That might look like ostracizing someone, pressuring them to drop or not support a complaint, or adversely altering their work duties or work environment. And some applications here could be criticizing someone or expressing anger or resentment toward them because they made a complaint of sexual harassment. Similarly, implying that someone is disloyal or is not a team player because they made a complaint of sexual harassment could be retaliation. So if you effectively create a hostile work environment for someone because of a complaint that they made or supported of sexual harassment, that in and of itself can also be sexual harassment.
Derogatory or provocative remarks about or relating to a person's actual or perceived sex, sexual orientation, or gender identity may constitute harassment. For example, talking about the sexual part of a person's body, or talking about their gender or sex or perceived gender or sex or sexual orientation, or challenging a person's gender identity can constitute sexual harassment. Now, I want to also emphasize that harassing acts or conduct that are directed against a person on the basis of the person's actual or perceived sex, sexual orientation, or gender identity can be sexual harassment. Now, an application of that, in other words, an example that's happened in other situations or jurisdictions, is propositioning someone or asking someone, whether it's a colleague or a staff member or subordinate, for sexual activity. I think that would be quite clear. But it also can involve what we have up here on the screen as a gray area. That could be comments about a person's body. For example, in another General Assembly, a comment was made that a woman who appeared not to be dressed warmly was, quote, probably having hot flashes, unquote, because she was, quote, about the right age. That would be wildly inappropriate, offensive, and also may constitute harassment. Comments about people's body, and especially women who are pregnant, is something that you should not engage in. I think that it happens quite often. People have told me stories also that when they're pregnant, people seem to feel it's okay to touch them or to ask very personal questions about their pregnancy. That is something that, even if it's not harassment, can really be a problem, can be very unprofessional, and make people very uncomfortable. So comments about a person's body, including a pregnant woman's body, is something that you should not engage in. Similarly, as we mentioned earlier about the chat function in Zoom, comments about how someone looks on Zoom, what they're wearing, how they're dressed, is something that is inappropriate and may constitute harassment. Now, related to this is not using someone's preferred pronoun, whatever that is, he or she or they. And someone's preferred pronoun is a pronoun that they want you to use. So use the pronoun that people indicate they want you to use it correctly, and please don't display any uncomfortableness with that or indicate in any way that it's inappropriate, unusual, or a subject for a joke. Respect the pronouns that people wish to be called. Another example of potential sexual harassment is any off-duty conduct that falls within the above definitions and affects the work environment. So we've now gone through a number of definitions and examples for you. Everything that we've covered over the last few moments, if that call occurs off-duty, which usually means outside the State House, but it affects the work environment, that also could constitute sexual harassment. So this, for example, could involve unwanted touching or other behavior at an after-hours party or some kind of lobbyist-sponsored event. On a related note, please remember, as Jen indicated earlier, if you're on YouTube or waiting for a meeting to start, what you say, what you do is still may be visible. It's still a work environment, and you still should act appropriately. And by the same token, your behavior or your statements in smaller Zoom meetings. So if there's a breakout session from a committee meeting, or you're having a Zoom meeting with a constituent or a stakeholder or a lobbyist or one of us on the staff, the same rules apply to those smaller meetings.
So just to sum up, we all have a right to a safe and professional work environment that is free from sexual harassment. Sexual harassment has no place in the State House or in our remote State House environment. If sexual harassment happens to you, no matter what your position is or the position of your harasser, you have the right to tell the person to stop. You might say, don't, or I don't like that, or you can leave the situation. If you're in a Zoom meeting, you could leave the meeting. But you do not have to put up with sexual harassment. None of us do. And it is your right, and you should feel empowered to tell someone to stop. We also want to remind you that under the policy, any legislator or member of the legislative staff who witnesses or is made aware of sexual harassment committed against anyone who is or who even appears to be under 18 years of age, that must be reported immediately to the Chief of Capitol Police and to the Sergeant at Arms.
Both the House and Senate have sexual harassment prevention panels. Via Rule Senate Senate Rule 101, the Committee on Committees is to appoint 6 panel members at the beginning of each biennium. Panel members have not yet been appointed for this biennium, but in the previous biennium, Senator Balint served as chair, Senator Benning as vice chair, and Senators Clarkson, Parent, Hooker, and Hardy also served on the panel. Turning now to the panel's procedure and the General Assembly's sexual harassment prevention policy. It should first be noted that any person who believes that he or she has been harassed by a legislator or by a legislative employee may identify that objectionable conduct to the individual. What the policy does is provide a procedure if this approach is either ineffective or if the person chooses not to attempt identifying the objectionable conduct to that individual.
So under the policy, there is an option to resolve a sexual harassment situation informally. And there are informal and formal processes for resolution in the policy. The informal resolution is available both to people who believe they have been harassed personally and to anyone else who has witnessed or is otherwise aware of behavior that may constitute sexual harassment. Information provided to a panel member in the informal process is generally confidential, except that the panel members can share information among themselves and with panel staff as is needed. If somebody chooses to pursue a formal process, the first step in that is to file a complaint. The complaint must be in writing and signed by the complainant. It does not have to be in any specific format, and it may be written by or on behalf of the complainant. It needs to describe the alleged conduct and identify the individual or individuals who allegedly engaged in that conduct. And it may be submitted regarding any current legislator or staff person regarding conduct that occurred while that person was a legislator or staff person. So it does not have to be in the current biennium or in any specific previous biennium, but it must be about someone who is currently in the legislature or on the staff regarding conduct that occurred when they were a legislator or staff person. And if there is a formal complaint filed, then a copy of that complaint would be provided by the panel to the alleged harasser, who's known as the respondent in the policy, and the respondent can file a response to the complaint if he or she chooses. The panel would then provide a copy of that response to the complainant in the case.
So the next part here is after the complaint's been filed, the panel can conduct an investigation either by itself or can retain outside counsel to conduct the investigation. And there are several potential outcomes of the investigation. The first is closure, if the panel finds that there are no reasonable grounds to support a charge of a violation. And it's important to note here that this is no reasonable grounds to support a charge of sexual harassment under the policy. And then the next is if there are reasonable grounds to believe that the respondent committed a violation of the sexual harassment policy, then the complaint is not closed, and it can result in a written warning to the respondent or a mutually agreed to resolution between the panel, the respondent, and the complainant, or it could result in charges and a formal hearing. The formal hearing process is confidential unless both parties agree for it to be open to the public. As there is legal counsel present at the hearing, under the Senate panel, the Senate secretary would provide legal counsel to the Senate panel, and then the respondent and complainant may have a support person present at the hearing or hire counsel at their own expense. And then finally, the burden of proof is clear and convincing evidence, which means that it's substantially more likely than not that the act occurred.
If the panel after the hearing finds that there is no clear and convincing evidence of a violation of the policy, they would dismiss the complaint. If the panel finds that the policy was violated, the panel shall impose or recommend corrective action pursuant to the applicable policies and rules. Now, the types and manner of potential correction actions are set out in the policy, and they include for legislators, counseling or training, potential removal from a committee, censure, or even expulsion. And for the staff of the General Assembly, corrective action could include counseling or training, a reprimand, a loss of pay or vacation days, demotion, or termination. Now, on pages 7 and 8 of your policy, the various bodies that would impose those sanctions are set forth. For example, whether it be Joint Fiscal Office, Joint Fiscal Committee for JFO, or the JLMC for our office. And once again, on pages 7 and 8, the various committees or bodies that would impose the corrective action are set forth. We're not going to review all of those today. Now, as to the time frame and confidentiality issues, according to your policy, the panel must act as soon as reasonably possible. There is no specific deadline or time period to investigate and take action, but they should act as soon as reasonably possible. As to confidentiality, the panel chair, speaker, or president pro tem shall issue a public statement for publicly noticeable corrective actions that occur, such as demotion or termination. In addition, panel members, attorneys from our office, Legislative Counsel, or the Senate Secretary, and any individual with whom the panel contracts in relation to a complaint are required to keep all related information confidential except as provided by the policy. And the records of the panel are not subject to the Public Records Act.
We wanted to make members aware that within our office, we have the role of facilitators. We have 2 facilitators, myself and Damien. And the role of the facilitators is to just be a resource for our fellow employees, to be able to explain what's in the sexual harassment prevention policy, to be able to explain what sexual harassment is, and provide information so that employees can decide whether and how to go forward if they feel that they've been sexually harassed. One of the most important parts of this role is keeping confidential the whatever an employee may come to us with. We may share the information amongst facilitators, but only with the employee's permission first. And it's our goal not to tell employees what to do, but rather to empower them to make their own choice about how he or she would like to proceed if they feel that they've been sexually harassed.
Similarly, legislative supervisors and the legislative council supervisors are also a resource for their employees in their offices who experience sexual harassment. The legislative council employees are encouraged and welcome, as are the employees in other offices, to speak with their supervisors about any situation that they have experienced or that made them feel uncomfortable. One important thing to note is that under the law, supervisors are legally required to take immediate and appropriate action to make the sexual harassment stop whenever they become aware of it. That doesn't necessarily mean pursuing the panel process. There could be simpler or informal actions that the supervisor can take, and likewise, if they're dealing with someone who is not a State House employee, for example, a lobbyist or a member of the public, they may have to take different steps to address that action that aren't addressed through the panel process. And finally, the supervisor's goal is to ensure a workplace free from sexual harassment. There are other resources as well. Individuals may not feel comfortable bringing the complaint through the State House process, through the panel process. So they can also bring a complaint in court through a private attorney. They can file a complaint with the Equal Employment Opportunity Commission in Boston, with the Vermont Human Rights Commission, which has jurisdiction over state employees, and also with the Vermont Attorney General's Civil Rights Unit, which has jurisdiction over state discrimination cases, and is also they also act on behalf of the EEOC in investigating federal complaints that occur in Vermont.
So finally, in conclusion, we are all regulated by this policy. You as senators, your colleagues in the House, and your staff are all regulated. But we're also all protected by this policy that prohibits sexual harassment. And we are all supported. We all support each other in making this a workplace that is free from sexual harassment. We all have a right to work in a safe and professional environment that is free from sexual harassment. Sexual harassment does not have a place in our State House work environment, our remote work environment, or in any other workplace. We can all be part of working together to foster a positive culture for our work environment. We can think about and be thoughtful about what we say and how we treat each other so that we make the State House a wonderful and supportive place to work. And we all have a right to report harassment and to take action as needed to make it stop.
That concludes our presentation. I appreciate everyone's attention very, very much. I would open the floor to questions, but I would ask Senator Ballant how she wants to proceed, if she wants to recognize questions, or what the best way to proceed is.
Luke, I'm comfortable with you facilitating the discussion if there is any.
Thank you very much. Now, with Zoom, one of the problems is you only can see half the people in any meeting when you have a large meeting. So I'll be going back and forth, but if you have a question, if you could please physically raise your hand or put up the symbol, and we'll be glad to call on you. Senator Hardy.
Thank you. Thank you all for that presentation. And I especially really appreciated that you added some information about our work being done in Zoom and some examples of inappropriate behavior via Zoom. That obviously wasn't a factor the last time we got this training, so I appreciated that update. And I have a question. I don't know if it's for Katie or Damien or maybe Senator Ballant, but I was on the panel this past session, and we had discussions about updating the policy. And Becca, you referred to it at the beginning with the new human resources officer. And I'm just wondering what the plan is in terms of process for that, or if there's a better time or place to talk about that. But that was just on my mind as we were going through it.
Yeah, great question, Senator Hardy. We are going to be waiting until she is fully onboarded, but she knows that will be part of the work when she comes in. So we will be operating under this policy until further notice.
Okay, but you do expect that the panel will work with her to update the policy or revise it once she's onboarded?
That is correct.
Okay, thank you.
And bear with me, I'm just going back and forth to see everyone's picture. Once again, if you have a question, please either wave your hand or raise a symbol, please. Senator Hooker.
Thank you, Luke. Senator Ballant, when do you expect that the panel will be appointed?
I have not met with the Committee on Committees yet on that issue, so I cannot give you a timeline, but it is one of the first additional committees I would like to be appointed. So I expect that very soon.
So it would be the new panel that would be...
The new panel, that's correct. It would be the new panel.
Senator Campion.
Thanks, Luke. So for those of us who, and I believe you mentioned this, but if you would just remind me, those of us who might have UVM students or other college students working for us during the session, do they go through this training as well? And if so, when is a good time for them to go through it?
I might be able to answer that question. We've been asked if we would be willing to do such a training for interns and other people similarly situated, and the answer is yes. I don't think it's been scheduled yet, but we would be glad to provide that if helpful.
And do the pages go through something similar that's age appropriate?
Jen, do you want to take that?
Sure. Yes, we have in the past, for the past several years, as part of the page orientation, done a modified version of this that is, as you said, more age appropriate.
Thank you.
Are there any other questions? Senator McDonald.
Or is he muted? Senator McDonald, you're muted.
Hit the space bar. There you go.
I think I'm unmuted now.
You are, Senator.
As circumstance would have it, just before we started this training, we were talking about clothing and dress, and we were joking. There was remarks about people's ties and bow ties and bow ties back and forth, and how it was just what we do before we meet. Was that open to interpretation? Was something like that a possible offensive activity? I think many of the people on the committee senators were on that warm-up session before we started this meeting.
I'll give my personal point of view for what it's worth. I heard that vigorous debate about bow ties. That didn't strike me as offensive. Senator, what we're talking about is maybe comments about how someone looks in a negative manner. Or with Zoom, we're all aware of situations where someone may be wearing a shirt and tie but dressed very casually from the waist down. There was a news reporter who got caught wearing shorts. Something that goes beyond just discussing bow ties or, oh, that's a nice tie, and gets into how someone looks. That could be a negative or insulting or has to do with a personal part of your anatomy. That's the kind of stuff you should stay away from. So we ask or suggest that everyone err on the side of caution. And Damien or Jen or Katie, did you want to add to that in any way? Did that answer your question, Senator?
Yeah, I figured that was probably the response, but where's the line? So thank you very much.
Sure. Are there any other questions from anybody?
I see Senator Rahm.
Well, Luke, I just wanted to appreciate that you raised the question about gender identity and expression. And I would think that the clothing that someone chooses to wear as it relates to their gender identity and expression is probably another way that might come up that could be offensive to someone.
That's a good point. Thank you. Or whether someone is wearing what's conventionally deemed to be the clothing of one gender or another. So thank you for raising that.
Yeah, I think a good way to summarize it is, if you'll remember from the very start, sexual harassment is a form of sex discrimination, and it's harassment on something on the basis of sex, whether it's a sexualized comment about someone's clothing or a comment about whether someone is conforming to gender norms in their appearance. Those things could all constitute sexual harassment. Potentially here. So that's really where we're drawing the line. A compliment on someone's tie, is fine, or a debate over whether or not, the benefits of wearing a bow tie when you're eating soup, for example. I think that's okay. But on the other hand, comments about, that could start to veer into that sexualized nature, or could be interpreted that way, that's where we start to run into the line. And I think one of the things that I've heard said is, if you hesitate, or you might hesitate and think, oh, is this going to cross the line? It's better to just be safe and not say it. That's generally, my rule here is, if you think it might cross the line, it's better to be safe than sorry.
Does anyone else have a question? Senator Balint, I don't think I see any more questions. I don't know if you do.
I have no questions. I'm just going to.
Thank you.
I want to thank Luke, Damien, Jen, and Katie for being with us this morning. They've done a lot of work on this over the last few years. And I just want to be clear, since it's on YouTube, that We are not doing this training because we have concerns about our new group of senators coming in. We do this training every single session. I just want to be clear. What's hard with switching from in-person to YouTube is you might get the impression that somehow this is somehow a new training. We always do this training. We're usually here in the State House all together. And we are just, for the sake of being open and transparent, we are allowing people to see what we go through with each new crop of legislators that come in. And when there are any changes to the policy, we want to bring everyone up to speed. So I know it's a bit awkward starting the session in this way. I appreciate your time and your patience and your seriousness with which you take this matter. And again, if you're interested in either rotating on to the committee or rotating off of the sexual harassment prevention panel, please do let me or another member of the Committee on Committees know. And I hope you all have a great weekend. Just want to remind there are a few committees meeting briefly this afternoon. I also see Senator McDonald has a comment or question.
If we're live to the public, it's difficult for most people to recognize that it's the President pro tem who is speaking and not Lieutenant Governor Gray, whose name is on the picture. So thank you.
Thank you. She's about a foot taller than I am and blonde, but but I appreciate the clarification. Anything else?
Ready? You ready?